Hello and welcome to my channel. I'm Leanne Newton and today I'm going to recap on some of the explosive events from this week in the Wayfarer and Blake Lively multiverse of lawsuits. You can also check out my threads on X, which were written in real time. My username is KiaraJ2001. I'm not a US attorney. I'm qualified in UK law. Everything I say is my personal opinion as someone who understands and interprets the law. It is not intended to be legal advice. I've had a few people say that the audio quality in some of my other videos is not great. We are working on that. We've only been going for 3 weeks, so it will take a little bit of time. Please bear with me though. We are ironing out all of these little issues. I would appreciate it if you could like this video and subscribe to my channel. You can also press the notification bell to be alerted to future content. I can't cover everything that has happened this week here today, so I will put together a short second video for anything I miss. I will be talking about the filings in order of the earliest filing, as they are before any subsequent responses. I will get to the responses later. Because this is a recap, there will often be responses filed by the time I record these videos. My video format largely follows my ex-post format. So we have Venable, which is Taylor Swift's law firm. They have filed a motion to quash a subpoena from Wayfarer in DC. The Lively's wrote a letter to Judge Lyman to complain about the Venable subpoena. Friedman responded, letting us know that Taylor Swift was being extorted. The Lively's file a motion to strike the letter. Friedman responds to the Lively's motion to compel with epic snark. Friedman then writes a further letter and submits an affidavit. Judge Lyman grants Lively's motion to strike. So Wayfarer has subpoenaed Taylor Swift's law firm in a DC court. Now I want to point out that this wasn't filed in a different court with a different judge in any effort to hide anything. The filing is made in DC because that is where the law firm being subpoenaed is located. So Venable represents Swift's brand and her music and TV rights. They have filed a motion to quash the subpoena from Wayfarer. Wayfarer's subpoena requests communications between Douglas Baldridge and the Lively parties regarding this lawsuit, documents between Douglas Baldridge and the Lively parties regarding this lawsuit, and communications between Douglas Baldridge and Michael Gottlieb regarding this lawsuit. I'm going to start by correcting something. I have been tagged in dozens of posts calling this Taylor Swift subpoena. It is not. The subpoena is for information regarding her lawyer, Douglas Baldridge, who is a partner at Venable. Taylor Swift has been served a separate subpoena which is alluded to in a footnote. The footnote confirms that a different subpoena was issued to a Baldridge client and service was accepted by Venable. There has been no motion filed to quash her subpoena at this point. I've also heard people talking about 3 subpoenas regarding Swift or her agents. I couldn't see a reference to 3 subpoenas on page 12, just what is quoted as different third-party subpoena. The third party here means a person who is not a party to the lawsuit, not a third subpoena. Wayfarer is under the impression that there are communications between Taylor Swift's lawyer and the Lively's and or one of their lawyers, and they are asking Venable for that information. In a nutshell, Venable is arguing that the subpoena is not necessary, as the same discovery can be obtained from the parties to the lawsuits. They also say that they were not on the film set and have no connection to the film. The judge will have to consider Wayfarer's reasons for requesting discovery from Baldridge and the scope when Wayfarer responds. And the judge here is not Lyman. This is another court and another docket. In footnote 10, Venable argues that awaiting the outcomes of the motions to dismiss could have relevance on what discovery is needed. So the lively parties, in response, filed a motion to intervene in DC. I've had a look, and I'm not going to go into any detail at all on this at this point. It is 5+ pages of "They made me do unscripted nudity," "He cast his friend as the OBGYN," and "They said he wants to bury me." Then it's followed by a further 15+ pages of "Wayfarer can't do this," "It's not fair," and "Any information you find will be harmful to us." I am paraphrasing, but it's the same thing I've seen in every single lively filing, so I'm a little bit sick of saying the same thing now. Also, in a spectacularly on-brand display of tone deafness, Lively throws in the unsubstantiated "Steve Sarowitz said he was willing to spend $100 million to destroy me" line, despite it being referenced in a recent extortion attempt where there was a kidnapping threat made on Sarowitz's daughter. This motion is Lively and Reynolds having a tantrum because Wayfarer issued a subpoena to Douglas Baldridge, a partner at Venable and attorney to Taylor Swift. At the time that this was filed, I did not know the context of why the subpoena was requested in the first place, to form any opinion over whether it was proper or not. I did, however, comment that I believe that the Livelies have something that they really don't want getting out. And in the filing, I did find this particular quote, which to me came across as poetically ironic. "The Wayfarer parties have chosen instead to seek any such documents or communications from a third-party law firm that has not appeared in the actions. An obvious fishing expedition to perform an end run around the discovery process in the Southern District of New York and deprive the Lively parties from the opportunity to object to an attempt to obtain their attorney's communications." It's been interesting to see both Lively and Jones squirming and filing motions within the same week on the basis that they feel a Wayfarer is depriving them of their rights to object to a third-party subpoena, in light of their actions with the Van Zandt subpoena. But more on that later. So then, in response to Wayfarer, the Livelies then went to Judge Lyman to make him aware, even though the request was filed separately in a different jurisdiction and under a different judge. The Livelies appear to be protesting that this third-party subpoena is improper. At the time this was filed, I said in my thread that I could predict how Wayfarer would respond. I made a point of saying that I believe the Livelies may end up regretting filing this with Judge Lyman and allowing Wayfarer to respond. I believe that was a fairly accurate prediction, as we will soon see. Also of note, the Livelies are copied in all of the law firms working for them into this letter, including the Texas firm involved in the Jed Wallace lawsuit. I don't know why they've done that, but I am curious. So then Wayfarer responded to the motion to compel, which we covered in my last video. Friedman points out that New York does not have jurisdiction over the Livelies' non-party subpoenas, which requires compliance in California, or the Venable subpoena issued by Wayfarer, which requires compliance in DC. And that is true. I said that I did not see the point of Lively's writing to Judge Lyman about a subpoena that is under a different judge at a different court. Friedman assures the judge that the non-parties intend to produce the relevant non-privileged documents in due course. Friedman also notes that neither Lively nor Reynolds has produced a single document themselves and has refused to provide information about the process that they use to search for documents that are responsive to the Wayfarer request. Then Friedman signs off with what is now, for me, one of his best lines yet. All that is known, though not disclosed by Lively, is that she improperly obtained defendant Jennifer Abel's documents from Jones' work pursuant to a so-called subpoena issued in a sham lawsuit filed without any notice to any of the Wayfarer parties, as detailed in our letter dated May 9th, 2025. Now, before we had the Wayfarer letter detailing their reasons for the subpoena to Venable, I had a theory as to a possible reason that may have been behind it. Thinking out loud here and complete speculation, but Douglas Baldridge is the attorney who handles Taylor Swift's branding and licensing. Her song, My Tears Ricochet, was the song used for It Ends With Us. The song is about Swift's battle with Scooter Braun over her music rights. It was the song that Lively was leveraging against Sony to pressure Wayfarer to remove Baldoni's A Film By credit. I had seen a lot of Swifties throwing around the image of Baldoni and Braun together. The image is at least 6 years old. I don't know whether Baldoni and Braun were friends, acquaintances, or were just photographed at an event together, given that they were both represented by Stephanie Jones at that time. But this image is being circulated as evidence of Baldoni supporting Braun's actions regarding Swift's songs, which it was not. And I wondered whether the song was deliberately chosen, and maybe that could have been the information Wayfarer was trying to get to with the Venable subpoena. And it turns out that, although the song choice may have been related to Scooter Braun in the eyes of Blake Lively when she chose it for the movie, it wasn't the reason why Wayfarer subpoenaed Venable. That turned out to be significantly more shocking. Less than half an hour later, Wayfarer issued a letter to Judge Lyman to explain their reasons in no uncertain terms. Friedman has written to Judge Lyman with the reasons they have subpoenaed Venable, and the frantic behaviour from the Lively parties now makes sense. Friedman alleges that 1. They have information that suggests that Lively asked Swift to delete their text messages, and 2. Lively's lawyer Gottlieb is alleged to have contacted Swift's lawyer Baldridge and demanded that Swift put out a statement in support of Lively. Allegedly, Lively threatened to release 10+ years of private text messages between her and Swift if Swift refused. So there was a demand for a statement of public support. That feels eerily like this. So this is from August 2024, and it is in the Wayfarer amended complaint. This is a statement that the Livelies wrote for Wayfarer to put out. They went through WME to try and pressure Wayfarer to take responsibility for all the problems on set. There appears to be a bit of a pattern being exposed here. Then Lively files a motion to strike Friedman's letter regarding her alleged extortion attempt of Taylor Swift. She denies any truth to the allegations, as expected, but what else is she going to say? Lively, in a stunning display of double standard, says that Friedman's letter is improper because it seeks no relief, is not relevant to any motion pending before this court, and is not useful to this court. And that's not true. If Lively is trying to tamper with evidence and threaten a witness in this action, it is relevant to this court. Lively explains that, although she filed a letter that sought no relief, was not relevant to any motion pending before this court, and was not useful to this court, her letter was okay because it was courtesy. Lively seeks a motion to strike the letter and reserves the right to move for sanctions. Then Friedman responds, pushing back against suggestions from Lively that his letter contained false representations about the Venable subpoena. Friedman notifies the court that he has attached the subpoena, which contains the factual basis for. He has attached a affidavit, which contains the factual basis for the subpoena. I am saying subpoena far too many times in this case. Friedman notes that Gottlieb did not sign the motion to strike. He also advises that the affidavit should cure the lack of declaration under oath that Lively has complained about. Friedman snarkily references Lively's letter that she filed to notify the judge of the subpoena, over which the judge has no jurisdiction. He points out the hypocrisy of Lively complaining that his letter was improper because it requested no relief and served no legitimate purpose. Friedman says, of course, the same could be said of the Lively defendant's May 13th letter, which Lively claims to have submitted as a courtesy and in which she did not ask the court to take any action. Friedman accuses Lively of submitting the letter to besmirch the Wayfarer parties and their counsel and states that his response was necessary. Friedman requests that the motion to strike be denied. But we now have the judge's ruling and Lively's motion to strike was granted. Now this may come across as disappointing or lead people to speculate that the judge is biased, and I want to talk about that. I've had a lot of people say to me that this is somehow related to his brother, Doug Lyman, working with Lively previously. To give some context, the quote-unquote work that people are referring to is a 3-minute long political campaign advert with the cast of Gossip Girl. And it was 16 years ago. I will leave a link to the video in the description, but unless Judge Lyman is a closet Gossip Girl fan, I can't see any bias stemming from this. Honestly, Adam Monshine was on screen in the It Ends With Us movie as the OBGYN longer than Blake Lively was in this campaign advert. Doug Lyman hasn't worked with her since, and he has never worked with Ryan Reynolds, so there is no basis at all for Judge Lyman to be accused of perceived bias because of it. The letters were stricken because the subpoena is being dealt with in a different court and by a different judge. There were multiple letters that hit multiple dockets. The issue is not for Judge Lyman to sort out, it is for Judge Leon in DC to consider. I have seen people saying that the judge has confirmed the letter to be defamatory or libelous. He hasn't. Those comments were comments which were contained within the case law he was citing. The comments also had the word inflammatory in there, and that is what the judge was referring to. When referring specifically to this case, the judge said, it concerns a subpoena proceeding in the District of Columbia over which this court has no authority. The sole purpose of the letter is to promote public scandal by advancing inflammatory accusations on information and belief against Lively and her counsel. Inflammatory was the key word, not defamatory or libelous. People are misquoting that because they don't understand how to interpret these documents. They see the words in the order and assume that the judge is attaching them as his opinion of Friedman's letters. But he is not. He is citing parts of case law to back up his position. The laws state that motions to strike may succeed where filings could be defamatory, or libelous, or inflammatory. Lyman has specifically referenced inflammatory, and it was clear that's what happened when you look at the filings from both Lively and Friedman that followed. And Friedman's letter did cause a media frenzy. I watched that happen in real time, so the judge is right. It is incredibly important to protect these proceedings. If the case becomes prejudiced because of the content of these letters and how the media reports on them, it could risk the entire case. Further down the line, it could cause a mistrial or taint the jury pool. It could also give lively grounds for appeal if Judge Lyman does not manage this correctly. I adore Brian Friedman, but he could have brought the information to the judge in a more discreet way through a phone call or a meeting in chambers, and I think that's what the judge expected too. Friedman's response effectively issued a challenge to Gottlieb. It said, "The motion claims that the facts set forth in the May 14th letter are unequivocally and demonstrably false, yet it is unsupported by any sworn declaration to that effect, much less from Mr. Gottlieb." He was saying to Gottlieb, "Here's my declaration under oath. Now show me yours." And the judge was not entertaining that public kind of fighting over information that has not yet materialized. I think Friedman knew this decision would be coming, but he was determined to get the information out to the public. Lively should not have written her courtesy letter either. That was a PR play. Friedman responded to counter the narrative and probably used the opportunity to win back the PR war. Now, if Friedman gets this evidence of Lively asking for text to be deleted and threatening Taylor Swift, then the matter will come back before Judge Lyman, and he will deal with it at that point, and harshly, is my guess. But right now, the evidence is still to be obtained, and that is taking place in DC. So Lyman's opinion is that it's not his problem to solve at this moment. It's as simple as that. This is not a win for Lively or a loss for Wayfarer. She can't get that information back out of the public, much like the text messages she put in the New York Times. So as all these filings were coming through and I was reading them, I started to see a bit of a potential legal strategy forming. We started with Jones Works complaining about the third-party subpoena to Edgeworth Security Services. They filed a motion to quash because they cited the documents as being privileged. Jones wrote 3 pages complaining about how unfair it was and asserting her right to object. So you get a sense that she does not like the fact that a third-party company has been subpoenaed for information that relates to her or Jones Works. In my last video, I talked about the irony of this, considering the circumstances of the Van Zandt subpoena that was served on Jones Works. If we were to compare that scenario with this Edgeworth subpoena, Wayfarer is playing the part of Lively, or Van Zandt to be correct. Edgeworth is playing the part of Jones Works, and Jones is now playing the part of Wayfarer. Wayfarer have essentially gone to Edgeworth and said, "You have information that may make Jones Works look bad. We'd like to have it, please." Unsurprisingly, Jones is not happy about it and is complaining about how improper it is. Then The Venable subpoena motion to quash entered DC, and Lively blasted out what has, so far for me, been the fastest response to any filing so far. She filed a motion to intervene, she cited various privileges, and in her filing, she made this statement, which we heard earlier. The Wayfarer parties have chosen instead to seek any such documents or communications from a third-party law firm that has not appeared in the actions. An obvious fishing expedition to perform an end run around the discovery process in the Southern District of New York and deprive the Lively parties from the opportunity to object to an attempt to obtain their attorney's communications. Now, if we compare the Venable subpoena to the Van Zandt subpoena, Wayfarer is playing the part of Lively or Van Zandt, Venable is playing the part of Jones Works, and Lively is now playing the part of Wayfarer. Wayfarer has gone to Venable and said, "You have information that may make Lively and her counsel look bad. We'd like to have it, please." Lively also doesn't like it. She's complaining about unfairness and impropriety. The two significant differences between the Edgeworth and Venable subpoenas versus the Van Zandt subpoena are that the parties whose information was at issue, and currently that's Lively and Jones Works, they were both notified to enable them to lodge the objections that they have filed. Wayfarer was not notified. Additionally, the subpoenas were issued as part of a legitimate good faith lawsuit with judicial oversight. Again, that did not happen with the Van Zandt subpoena. Yet, Lively and Jones don't think it's fair. Despite their lawyers happily parroting that the Van Zandt lawsuit was normal and proper. Lively objected so much that she wrote a letter to Judge Lyman about the Venable subpoena, which is not even on Lyman's docket, or even in the same jurisdiction currently, and referred to it as an abusive end run of discovery processes. To be clear, Friedman is genuinely seeking the information subject to the subpoenas in good faith. I have no doubt of that. But I think he's seen an additional opportunity based on the responses from Lively and Jones. Lively and Jones have just been played into going on record to admit that their subpoena to Jones Works, by their own standards, was unfair and improper. Keeping in mind that the Van Zandt subpoena was arguably more improper due to lack of notice or good faith lawsuit. So with the Van Zandt lawsuit recently being brought before the judge, I think Friedman has now got on record that both Lively and Jones don't think it's fair to obtain information through third-party subpoenas and highly value their right to object and assert privilege. I think Friedman is making the case that the evidence from Van Zandt subpoena, the text messages, should be suppressed, and now Lively and Jones are no longer in a strong position to argue. If Friedman is successful, Lively's retaliation claims will fall apart. That's just my opinion. I don't know whether that is the strategy, but I'm trying to see these things. If I were Wayfarer's attorney in this case, this is how I would litigate the case. Finally, I've seen many pro-Lively people comment that a law firm like Wilkie, Farr and Gallagher would never engage in the kind of nefarious actions that Friedman has alleged of Gottlieb. Firstly, as a blanket statement, that is ridiculous. They're not supposed to, but there have been cases of lawyers being corrupt. Of course there have. It's deplorable, and it brings the profession into disrepute, but it's absurd to say it never happens, or that because a lawyer works for a top firm or went to a top university, that should be taken as reassurance of their character. And secondly, if you think Gottlieb's firm would never hire corrupt lawyers, then please Google Gordon Kaplan. Kaplan was the co-chair of Wilkie, Farr and Gallagher, Michael Gottlieb's firm. In 2019, He went to prison for taking part in what was known as the 2019 Varsity Blues scandal, in which he was one of about 50 people who devised a scheme that enabled people to rig tests or fake athletic records to get their kids into top colleges. Kaplan went to prison for a month, was fined $50,000, and was suspended from practicing law for 2 years. Now, I'm not suggesting that this is concrete proof of any alleged misconduct by Michael Gottlieb. It is not. I mention it to show that even big reputable firms like Gottlieb's hire lawyers who are prepared to commit unethical acts and even break the law. So when people cite a firm's reputation as the reason for not believing a potential allegation rather than actual evidence that is directly related, I can't get on board with that argument. For me, Friedman put out a sworn affidavit regarding the information he had received. That is a very big step, and I fully believe he has something that he has verified and vetted. Now, I have one final request. Please check out my friend CJ's channel. So that's Citizen Journalist 24. We've been sleuthing and talking about all things about this case since the beginning. She has just this week begun a series called Objection Courtroom Chatter. I'm going to guest with her on that whenever I can, and we talk about the various cases going on, including cases beyond Wayfarer and Lively. I'm incredibly proud of her, and she is doing such an amazing job. I love her with all my heart, so it would mean a lot if you could go and support her channel and watch the videos. I will leave a link in the description. So that is it from me for today. Thank you for joining me. I will see you all soon. Goodbye for now.